So basically, thank you for listening and thank you for watching. So subscribe to the channel, like the videos, and stay tuned basically. Thank you for always following us on our media platforms basically and here. And just I wish you success in whatever you do basically, or in whatever you read or whatever you endeavor to do, and success in the law school, because I know you're a lawyer or you're a law student listening to this. So basically today we are under co-ownership of land. And co-ownership of land, we can say that this is the ownership of land by two or more people. Basically, that's what we can define it. That the ownership of land by two or more people. Basically, that is co-ownership of land. Basically, and we have two forms of co-ownership. Basically, we have joint tenancy and tenancy in common. Those are the two forms of co-ownership that we have. We have a joint tenancy and a tenancy in common. So basically, co-ownership, basically, at times in normal life, we also live in life of co-ownership. As we shall see, how a co-ownership can be what? Can be regarded basically. Some of us, we have family property that our father left it for us, but we realize that we all have the same interest in that property, but we don't know that. So that is also a form of co-ownership, as we shall see basically, that essence. So co-ownership, I've said that is the ownership of two or more people. Ownership of land of two or more people. The same piece of land, the ownership of the same piece of land by two or more people. The two forms that you have seen joint tenancy and tenancy in what? And common. Tenancy in common, in this essence. So first of all, I'll start with what they call a joint tenancy. However much we see that we have a joint tenancy in common, it was brought in as a result of equity. Basically, note that in mind. First, common law brought a joint tenancy, then equity brought in a tenancy in what? In common. So basically, what we shall show here, or what we shall see, first of all, we shall see a joint tenancy. Joint tenancy, this is the ownership of land in undivided equal shares. It is the ownership of the same piece of land in undivided equal shares. Basically, that is the concept that we can see here. You own land in undivided equal shares with the right of what? Survivorship, as we shall see in this essence, with the right of what? Survivorship. Basically, that is co-ownership, as you see. We have the case of Hammersmith versus Hammersmith LBC versus Monk, in that essence. So it was a case of 1992, whereby they held that where people presume or where people own land jointly, there's a presumption that they own that land in undivided equal shares. That whatever we shall see, basically, that they have those undivided shares. Actually, even in that case, they speculated the four unities that we have, that for a joint tenancy to be present, or for joint tenancy to be present, there must be evidence of what? Of the four unities, basically, of the four unities. In this essence, all what we look at as the four unities, they're the ones that show that where they are available, there is proof of what? There is proof of co-ownership, or there is a proof of a joint tenancy, basically. So the first unity that we are going to see, or the first unity that we are going to see, it is the unity of possession. Basically, the unity of possession. Now, the unity of possession, basically, in this essence, it means that you are owning this land. All of you are owning that same piece of land equally. That possession, you are possessing it equally, without being challenged, without anything, in this essence. So that is the quotation that we do, that we see in this essence. So basically, note that in mind, that in this essence you are owning that land equally, without being without being challenged. That is the unity of possession. We have the case of Wiseman versus Simpson. Basically, the case of Wiseman versus Simpson. Basically, in the case of Wiseman versus Simpson, the quotation was that where the land is owned or where possession is equal, there is a presumption that there is a what? A joint tenancy. There must not be anything that the possession is, you are not allowed to possess some portion of land. No, you all have the possession of that piece of what? Land to be regarded as a what? As a joint tenants, basically. So that is the quotation we see, or that's the quotation we look at, basically. Then another one, we have the unit of interest, basically. Unit of interest, or what you see that a unit of interest is that you all must have the same interest in the land, basically. You must have the same interest in the land. Same interest, it means that if at all, let me give an example, that the unit of interest is that if at all it is a lease, you have both a lease. If at all it is a legal interest, you have a legal interest. If at all you have an equitable interest, it must be the same. Basically, you must all have the same interest in the land. There's no one that is owning land in the lease. Someone is owning it in the freehold, someone is something like that. So the unit of interest, it means you are all owning the land with the same what? With the same interest. Then we have the unit of title. Basically, there are 4 unities. We have the unit of title. The general rule is that under unit of title, it says that the certificate of title must have all your names. That if you are 4 co-owners, all your 4 names, Chiza Muzafaru, Mukasa Peter, Matalo Simon Peter, Walusimbi Walter, all your names must be on that certificate of what? Of title. Basically, all your 4 names, for it to say that this is a joint what? Tenancy. So that is the unit of what? The unit of title. Then we have the unit of time. The unit of time, it means that you must have the same duration. You must have occupied the land at the same time, and the duration you have on that land, it must be the same. See, not saying that one of the co-owners is going to be the land for 1 year, the other co-owner is going to be on land for 2 years. No, that one doesn't act like that. It means that all of you must have the same duration of the land, and you must have entered at the same time. We have the case of AG Securities versus Vaughan. Vaughan is VAUGHAN versus Vaughan of 1988, basically, in this essence. In this essence, what court specialized said that these people had the 4-bedroom house, so but they entered in different intervals, basically, and the time wasn't the same that they had to spend there. So court held that that couldn't be regarded as a what? As a joint tenancy. So basically, that was what was quoted there, in that essence. So basically, those are the 4 what? Those are the 4 unities for a joint tenancy to be what? To be present, basically. Another thing that which is key, it is the right of survivorship. Under a joint tenancy, there must be a right of survivorship. Basically, where there is no right of survivorship, that is not a joint tenancy. It is a tenancy in common. What does a right of survivorship mean? A right of survivorship, it means that if one of the co-owners die, his interest or his share shall be taken by the surviving what? Co-owners, basically. So that is the essence that we are looking at. That the surviving co-owners will take his portion, basically. That's the quotation. That under the right of survivorship, in case one of the co-owners die, his people won't take his share, that I have children, I have what? No. But the surviving co-owners will take the what? Will take the portion, basically. You get? In this essence, right of survivorship, be keen. Follow this assertion until we shall end. We shall see how this right of survivorship can be taken away. We shall see it, basically. So that is the quotation that we do what? That we see here, basically. So now that is a right of survivorship, which is a specific characteristic, or which is a specific characteristic for joint tenancy. Then I've told you that we have 2 forms, basically. Then we go to a tenancy in common, basically. A tenancy in common. A tenancy in common, it was brought because of equity. Basically, tenancy in common, it was brought as a result of equity. Remember, they said, equity, these are rules of fairness and natural justice. And equity came to, follows the law, it came to address the rigidity of common law, basically. So a tenancy in common, it came to ensure that at least there is a certain fairness in ownership. That's why for it, tenancy in common, they defined it that this is the ownership of land in unequal, this is the ownership of land in equal shares but distinct shares, basically. This is the ownership of land in equal shares but distinct shares. What do I mean equal but distinct shares? It means even joint tenancy, it is equal. I don't know whether I made a mistake calling it unequal. No, maybe I made a mistake, but it is also equal shares. So in this essence, what do I mean by equal shares but distinct shares? Distinct shares means that you have a portion. Basically, in case you die, someone can take your portion, and you have where you say that you have strategized. My land is this side. Basically, you have where you can locate yourself on the land, unlike in the joint tenants. That's why under tenants in common, these are the characteristics that is entitled to. There is equal. There are equal shares. Basically, there is equal ownership of land. Shares are undivided. Shares are distinct. Shares are undivided, but shares are what? Distinct. We also have no survivorship. No right of survivorship under a tenancy in common. So basically, that is the characteristic that we can see, basically. And remember, a joint and a tenancy in common, it is provided under section 56 of the Registration of Titles Act. Basically, as you read the section, it is there. Section 56 of the Registration of Titles Act. A joint tenancy, we have seen the characteristics. This is the ownership. This is the ownership of undivided land in equal shares. Basically, equal shares with the right of what? Survivorship. Basically. Hope we are on the same page. Anything that you feel that it is not clear, please put it in the comment section. We shall address it. Though I have a lot of comments that come in, but I try to ensure that at least I fulfill some of the comments that I can at a time. So basically, that is the quotation that we see there. So another essence that we see, we are going to look at the creation of a joint tenancy and tenancy common. Basically, we shall briefly first look for the creation of a joint tenancy. A creation of a joint tenancy, one of it can be created under what? Under statute. That is section 56 of the RTA, Registration of Titles Act. Creation of under statute, that is creation of what? A joint tenancy under statute. Secondly, it can be created through grants made to two or more people. Grants made to two or more people, it can create what? A joint tenancy. For example, you have the case of Remuram, Monta. Is it Mata? Muta. Remuram is M-U-R-R-A-M. Manta is M-U-R-T-E-R. So in that essence, court held that where they grant a property to two or more people, there's a presumption that that property is owned in a joint what? Tenancy. For example, let me give an example. That if your father dies, basically in this essence, and says that I have a building in Kampala. That building, I've given it to my 4 children. So at a moment, those 4 children become owners or become joint tenants of that what? Of that property. Until otherwise, when they decide otherwise, but at the moment, they become joint tenants of that property because they have been granted that property in undivided shares, but they have been given that what? That property, basically, that quotation. Secondly, under creation of a tenancy in common, it can also be created under statute. That's section 56 of the RTA. That is the Registration of Titles Act, basically. That is one way. Another one, it can be created through property or through contribution on funds on property in unequal shares, basically. You can contribute funds on the property in unequal shares. Where funds are contributed on the property in unequal shares, there's a presumption that it's a tenancy in what? In common. For example, let me give an example that when for example you want to buy land, the other one brings 20%, this one 10%, 50%, 60%. At the end of the day, we cannot have equal shares. That is the fact, basically. So you brought money that was less, basically. So that is the one of the circumstances. Another one, also where property constitutes to a partnership asset. You can have a partnership business or where property constitutes to a partnership assets. At the end of the day, that is a tenancy in common, because in the dissolution of a partnership, they give you your share, basically. So that is the quotation, or that's the point we do what? That we see. Thirdly, also, where we see where property was held in security for a loan, basically, advanced by some of the co-owners, basically. So where property is owned as security for a loan, basically. So there is a presumption that is in tenancy in what? In common. So basically note that in mind. Those are some of the creation of a joint tenancy and a tenancy in what? In common, basically. Then I want us to look at the rights of co-owners, basically. Rights of co-owners. The other point, or the point that I can say, co-ownership is also a defense under trespass to land. And in this essence, it is one of the first rights that we shall look at. The right to no liability to trespass and occupational rent. They are not liable for trespass, co-owners, basically. That is one of the rights. We have the case of Jones versus Jones. Jones, Jones versus Jones. Right to no liabilities for trespass and occupational rent. Whereby the other one party owned a quarter and another one owned 3/3 of their quarter. So at the end of the day, when this one wanted to chase away the other party, could tell that they had owned this property as a co-ownership property. So this person was not liable for trespass because they had been there and there was a tenancy in what? In common, basically. So that is the concept that we do what? That we see there, or we point at in this essence, basically. Then we also we have the right to no compensation for improvement. That co-owners are not entitled to compensate improvements made by other co-owners. But however, where equity intervenes, by the time you share where there is sale, at least the other person must be compensated for some of the improvements that he has instated on the what? On the land. But joint tenancy, the tenant is not liable for compensation for the improvement. So once you put the structure, or once you improve land and it brings a lot of wealth, it's depreciation changes. At the end of the day, your co-owners cannot pay you for those improvements. They cannot pay you. But however, they can only give you at equity. Once there is a sale, they can add you some money, some top up for the improvements that you made. Another one, we see that right to account for the profits, basically. Profits attained from third parties, basically, or received from third parties. You have the mandate to account for them. For example, you may lease the land. At the end of the day, person will come and say, the rent that is being paid you under the lease, we aren't seeing it. So some of the co-owners, they have a right to ask for account of the what? Of the profits, basically. Received from third parties or received or get from third parties. You can lease, you can do anything, basically, in that essence. But the quotation here is that the rent that you receive, it must be simply from third parties, basically. But the profits that you make as a person, you are not accountable for them in this essence. The case of Anderson versus Eason. Eason is EASON. That essence provided for that one, for that element in this essence. So that is the quotation that we see in that essence. So under co-ownership, also another topic which is vital that we are going to look at, it is the topic of termination. Termination of a co-ownership, basically. This is the key topic. Termination of a co-ownership. First of all, we shall look at, actually we shall combine termination of a joint tenancy and a tenancy in common. By the general rule, you cannot terminate a joint tenancy direct. But however, you terminate a joint tenancy, it becomes a tenancy in common. From a tenancy in common, that's where it ceases from being a co-ownership, basically. So for you, where you want to terminate a joint tenancy, you terminate it, it becomes a tenancy in common, then it ceases from being a co-ownership, basically. And one of the elements that we are going to see under termination, it is the severance, basically. Severance is S-E-V-E-R-A-N-C-E, severance. Severance, it means that I want my part, basically. I'm tired of this, give me my share, we part ways, basically. Severance is, it means that you are tired and you need your share in this essence. That is severance, or that is, severance, basically. One of the elements or how termination can be done, basically. Under severance, you have like three elements, and actually there are 5 elements under severance. How severance can be conducted, basically. And these elements are in the case of Williams versus Hensman. The case of Williams versus Hensman, Hensman, Williams versus Hensman, it provided for these elements of severance. One of it is unilateral severance, basically. Unilateral severance, it means that where there is a breach or where there is an act which destroys any of the 4 unities, the unit of time, unit of possession, unit of title, and unit of what? Interest. Any act that destroys any of the 4 unities, that is a unilateral what? Severance, basically. Then the second one, we have severance by mutual agreement. Severance by mutual agreement, you can agree as co-owners or as joint tenants that, you know what, let's end this, basically. You end that and you part ways, simply. Basically, that is severance by mutual agreement. We have the case of Mayanja Nkanji versus National Housing, basically. Mayanja Nkanji versus National Housing, the quotation was that, you know what, the joint tenants can agree. They can sit on table and say that, you know what, we are tired of this. Let everyone have his what? His share, basically. So that is mutual agreement. Then we have severance by cause of dealing. Severance by cause of dealing. Cause of dealing deals that when the parties or the joint tenants, in the way they are dealing, there is a presumption that they are tired of the joint tenants. For example, remember, under joint tenancy, you own land in undivided equal shares, basically. But you start seeing people are putting barriers, are putting restrictions. So that is in the course of dealing. The presumption here is they want to sever the joint what? Tenancy, basically, in that essence. So those are some of the 3 elements of severance that were provided in the case of Williams versus Hensman, basically. The other elements still under severance we have by court order. Severance by court order. Court can order the parties to sever, basically. Court order, for example, I gave an example whereby you have 4 children and your father dies and gives you a building. It has like 6 floors. He gives you a building and says that I've given that building to my 4 sons or my 4 children. At the end of the day, you start fighting, what and what, you go to court. So court can order for you to sever. It can give everyone his portion in that building, basically. So that's severance by court order. Court to intervene and it divides the property on your behalf for you, basically. So that is the essence. Then we have severance by a consequence of unlawful killing by one joint tenant, of the severance by the consequence of unlawful killing of one joint tenant by his or her fellow joint tenant. In this essence, this deals that where one of the joint tenants kills a fellow joint tenant. At the end of the day, a joint tenancy ceases and it becomes a tenancy in what? In common. The key element is that he loses the right of survivorship, because most of the people kill fellow joint tenants to own the whole property. But where a court gets to know that this person was killed because of that, at the end of the day, he loses the right of what? Survivorship. We have the case of Ristane of 1989. Ristane is S-T-E-N-E, 1980, where the husband and wife had a property in joint. But however, their wife killed the husband. So when court realized, they held that he had lost the right of what? Survivorship, because he had connived in the killing of the what? Of his husband. It changes in the right in tenants in common. Remember, tenants in common, it is equity, whereby if one of the co-owner dies, the property goes to the people he wants. Actually, the property goes to his or her successors, unlike it doesn't go to the surviving what? Co-owner, basically. So that was the quotation here. All this is the quotation here, basically. Then that is severance that we have talked about. That is severance. Then another termination point is conversion in sole ownership. Conversion in sole ownership, it means that the property is put in one person, or in the sole ownership of one person. We have the case of Bedison versus Bedison, B-E-D-S-O-N, Bedison versus Bedison, that the ownership of property was put in one person, basically. And the one person that they put in, it means that they have terminated the co-ownership. It is no longer there. Remember, co-ownership is the ownership of two or more people of the same piece of land. But where ownership is put in one sole person, or in sole ownership, it has terminated the what? The ownership as a result. So that is the quotation there, basically. Then we have by partition. Partition is dividing. You remember we studied the partitioning and scrum of Africa, or by East Africa. So in this essence also, termination of co-ownership can be made by partition. Partition means that you start having your share. Every person is given his share, basically. So that is the quotation, where each person is given its share and each person starts claiming for a title to his land, basically. Remember, under unit of title, all names must be on one title. But under partitioning is that each co-owner is claiming for his title, basically. You have the case of Singh versus Kaur. Kaur is K-A-U-R. Singh is S-I-N-G-H. Singh versus Kaur. This essence where court held that where the co-owners start claiming a title to the land, it gives an element of partitioning. And partitioning, it terminates what? Co-ownership in this essence, basically. So that is the quotation, or that's what the quotation that we see. Then the last termination point is termination by sale, basically. Termination by sale. What do I mean by termination by sale? In this essence, the land is sold, and each basically, where land is sold, each co-owner receives his share according the way he contributed, basically. And the co-ownership ends when each person gets his share. That is termination by sale. That you may decide as 4 co-owners, let's sell this property. After selling, the money is divided into themselves according to your contribution, basically. So, and the co-ownership, it ends immediately. The money is divided to each person, and each person gets his share. That is termination by sale, basically. So basically that is the topic of co-ownership in land, or in co-ownership in land law, basically. Feel free to ask in the comments whatever you feel that you haven't understood, and I'll be in position to answer those comments, basically. Other than that, I thank you for always watching to the channel, and be blessed. Thank you very much. Yes, thank you for watching. Thank you for being on the channel. Subscribe to the channel, like the videos, share the videos, and stay on. Thank you very much for always watching. Stay blessed and be blessed. Continue watching.